May I please, Your Lordship? My Lord, I beg to mention item 10. We were supposed to file our affidavit. We need some more time, my Lord. I've taken consent from the petitioner in person.
You are for respondent?
Yes, my Lord. State respondents.
Okay. Oh, who is the petitioner in person?
My lord, I am.
Yes.
My lord, let the affidavit come first, my lord, and then if my lord will be pleased to fix on 26th, my
of
lord.
May.
This 26.
26.
26th of May.
Me. Okay. Petitioner in person is present. Mr. Swinsul and its government advocate has sought for and is granted. How much time you need?
3 weeks.
Okay.
For
4
the
weeks time?
4 weeks.
4 weeks time to file counter affidavit on behalf of the state respondents. As sought for and agreed to by the learned counsel for the parties, leaves the case on 26 May.
My lord. Much
Obliged. Obliged, ma'am.
May I please, Your Lordship? Your Lordship, I beg to mention item number 15 with the consent of the other party, Your Lordship.
Criminal appeal.
Yes, Your Lordship.
You are for state?
I'm for the private respondent.
Yes.
Mr. K. Tama, he is unwell, Your Lordship. So therefore, on medical ground, I'm seeking adjournment today.
Yes. Okay. Who is
I'm
for
the
appellant?
amicus. I'm for the appellant.
my lord.
Okay. Mr. Miss S.V. Dara,
Darang.
learned amicus curiae for the appellant, and Mr. Learned additional public prosecutor.
Yes, my lord.
Okay. For the state are present. Mr.
J. Sring,
Learned counsel on behalf of
K.
Mr.
Tama. K. Tama.
Learned counsel for the respondent number 2 has made a prayer for adjournment, as the prayer for adjournment is not opposed by the learned counsel for the other sides, the prayer is allowed, leaves the case on after 4 weeks.
After 4 weeks.
After 4 weeks.
Most of them.
Highly obliged.
Your Honor, I beg to mention item number 16 and 17, which is also a criminal jail appeal. I'm the amicus in that case.
Yes.
The PP is, he has telephonically informed me that he's out of station. PP Tado.
Hmm? This is like this.
Any fixed date?
So when he will be able to represent?
I'm not aware.
Next week.
Maybe. Fixed date, Your Honor. Your Lordship.
Fixed date,
Any fixed date?
day after tomorrow.
Will do.
Yes.
But Tato, that he's attending. He's one of the ailing of relatives at Guwahati, Lordship.
Okay.
So next week, Lordship.
Next week.
Lordship.
Okay. Miss S.B. Darang, legal counsel, stroke amicus curiae for the appellants is present. Mr. Swinsul, learned counsel on behalf of Mr. Ering or Searing.
Searing is the LSC.
No, on behalf of Jita,
LSC for the.
Jita.
Edison PP.
Learned additional PP. Made a prayer for adjournment for 1 week. Release the appeals on next Wednesday, next Tuesday. No? Tuesday.
Tuesday. Most of.
Lordship, I beg to mention item number 18, Your Honor. So, Lordship, conducting counsel is out of position due to this some domestic issue. Lordship.
A prayer for adjournment is made on behalf of the learned counsel for the appellant. The prayer is not opposed by the state council. As sought for, the appeal stands as one for a week.
Lordship, mathematics on 25 of May 2016.
Okay. As sought for and agreed to by the learned counsel for the parties, list the case on 25. 25 is 26. 26 May.
26. Deeply obliged.
Appeals are not done. Yeah.
May I please, Lord.
Yes,
My Lord, I like to mention item number 8, my Lord.
8.
Yes, my Lord. In the main petition, my Lord, respondent number 1 and 2 have filed their affidavit yesterday, my Lord.
In a main writ petition.
Yes, my Lord, in the main petition, my Lord.
Main
That is not
petition
listed
is
together, my Lord.
Sangit. Respondent number 1.
1 and 2 have filed their affidavit yesterday only, my lord.
Okay.
I need some time to file my reply, my lord.
And who is for the applicant I?
Lordship, I have filed commission. APPSC has filed the IA, your Lordship.
So whatever the prayer,
Lordship, short date may be given because
how much time?
there's an
will it take?
urgency.
My lord, 2 weeks, my lord. Let it be fixed on, my lord.
Mr.
Photo, my
Mr.
H. Lampu, my lord.
Learned counsel for the writ petitioner has submitted that a respondent, he has received a copy of the counter affidavit filed on behalf of the respondent 1 and 2 only yesterday. And he needs 2 weeks time to go through the same and to file an affidavit in reply if so advised. In the meantime, first off, he has thus sought for listing of the case after 2 weeks. Ms. So-and-so, learned standing counsel, PPSC,
Lordship.
is present and has submitted that okay, is present. First off, in view of the prayer made, list the case on so-and-so.
Fixed date.
After 2 weeks,
Lordship,
list, give it.
5th May.
Oblige.
May I, Lordship? Your Lordship, I beg to mention item number 5. The leading counsel, Mr. Dilaji, is unwell today.
Okay.
So the matter may be
You are Mr.
Tinalo, Taminalo,
Learned counsel on behalf of Mr. D.
Dilaji,
Learned counsel for the petition
appearing
has
for appellant.
submitted that Mr. Laji is indisposed. He has thus sought for listing of the case after 2 weeks.
Your Honor, matter may be fixed tomorrow or the after tomorrow.
Day after tomorrow? Okay. Release the case on so-and-so.
Much obliged.
Day after tomorrow.
Item number 1.
Ginny.
Lordship, in this matter, Lordship, I've been appointed as the legal aid counsel, Lordship. Paper books are ready. I have received the paper book also,
You
Lordship.
are ready?
Lordship, today, in fact, I have got a call from the London
PP.
PP.
Oh, it is in PP, Lordship. Jita is appearing.
Is
Lordship.
out of station.
This matter may be,
It
Lordship.
appeals, no legal aid counsel. Legal aid counsel. Some condonation, delay condonation. It
It
has
was-
been done.
It has been done, Lordship.
Okay. 302,
Correct, Lordship.
not yet admitted. Will admit? Huh? Admitted. 23? No. Okay, bill is admitted. Okay. Heard Mr. J. Zini, learned legal aid counsel for the appellant, and Mr.
Deloy.
Learned additional public prosecutor for
Lordship
corresponding
PP.
state. Post of. It is submitted by Mr. So-and-so that Mr. Z,
Deloy, Lordship.
who is appearing for
Oh, Jita, the Lordship.
Tado, learned additional public prosecutor, would represent the state in this appeal. Post of. As the appeal has already been admitted and the paper book is ready, list the appeal for hearing on so-and-so date. Give it.
On 30 April. Item number 2.
May it pleases your lordship.
Yes.
My lord, this PIL is with regard to implementation of the ICDS scheme in the 6 villages, lordship, wherein the petitioner has made a survey and there are some non-availability of Anganwadi centers. And which is also violation of section 4 and 5 of the National Food Security Act, Lordship. Although the notice was issued, Lordship, way back in the year 2025, 15/5/2025, but till date, no affidavit is being filed by the state, by the respondent authorities.
Yes.
Lordship.
Contempt not yet filed. Respondent number 1 has filed an affidavit.
Yes, Lordship, we have filed.
State has filed an affidavit.
I'll then receive, Lordship, that.
Yes, state has filed an affidavit. And on 31/3/2026.
I'll receive that, Lordship. When might be my clerk has it, because since I don't have any local counsel over there, I'll receive it.
Okay, it runs into 446 pages. Oh, sorry. It is about 200 pages. So,
I'll receive it, Lordship. Maybe
Okay.
my
okay, what is the stand in the affidavit?
Lordship, we have filed in detail affidavit. We are working on it, and as per the Anganwadi buildings, Lordship, due to old, it seems somewhere built long time ago, Lordship. Due to time factor, some are in deteriorating stage. We agreed to that, Lordship. But then there is provision that if it is in deteriorating state, Lordship, we can hire a rent also. And then if rent is also not available, some AWC can be run from the workers' home also. AWC workers' home also. Lordship.
Yes.
And food distribution, Lordship, and learning material distribution, all we have annexed, Lordship.
Okay, Ms. Ghose, you go to the affidavit.
yes, Lordship.
Find
Yes,
out.
yes, Lordship.
Heard Ms. D. Ghose, learned counsel for the petitioner to the virtual mode. Also heard Ms.
G at the Lordship.
G. Ette, learned state counsel for the respondent number
1 and
1 and 2. And Ms. 1, 2,
Lord,
5.
1 to 5, Lordship.
1, 2, 5, 4, 5, 6, 7. And Mr. So-and-so, Learned Deputy Solicitor General for the respondent number 3. So stop. The respondent number 1 has already filed an affidavit in opposition. So stop. Ms. D. Ghose, Learned counsel for the petitioner, has sought 2 weeks' time to go through the same and to file affidavit in reply if so advised, if required, within 2 weeks' time. The process the sought for listing of the case after 2 weeks.
Lordship, I will humbly pray for Lordship for fix date, Lordship.
Release the case on so-and-so.
7 of May.
7th of May.
7th of May. Yes, Lordship.
Obliged.
Keep.
Item number 3.
Look, my
Okay. What is this about? Okay. Yes.
On the last occasion, Lordship, direction was given to file affidavit, Lordship, to respondent
Yes.
number 1, Lordship.
It's been filed already.
Now it has been filed.
Okay, I'll receive it, Lordship. It may be fixed on the same date, 7.
My lord, right from the beginning, my lord, I have raised the my lord maintenance of this present PL, my lord. Now, if your lordship sees my lord, last order also, that my lord scope was open, my lord. I don't want to any reference to my sister, my lord. So for maintenance, any that may be fixed, my lord, so that you can argue on maintenance, my lord.
Okay, 7 May.
Yes,
Seven,
7th
very
May,
well.
Lordship.
Very well.
Yes,
Heard
Lordship.
Ms. D. Ghosh, learned counsel for the petitioner through the virtual mode. Also heard Mr. R. H. Navam, learned additional advocate general for the state, respondent number 2 to
2 to 5, my lord, 2 to 5.
and who is for Mr. Kato?
My lord, in this matter, my brother will appear, my lord.
Mr. Keloya, learned. Central Government Council. Yes, for the respondent number 1. Post of. An affidavit in opposition has already been filed on behalf of the respondent number 2 on 9/4/2026. Post of.
7 May, na?
Ms. Ghosh, learned counsel for the petitioner, has submitted that she would receive a copy of the said affidavit in opposition and given 2 weeks' time, an affidavit in reply would be filed if required. Post of. The praise allowed. Post of. Mr. Navam has reiterated the issue of maintainability of the PIL. Post of. In view of the prayer made by Ms. G. Ghosh, Ghosh raised the case on 7/5/2026. The issue of maintainability is kept open for consideration on the next date of listing.
May I pray, my lord, one thing, my lord. Since, my lord, as per the department, my lord, in the entire petition, my lord, the PIL, my lord, the allegation is made against the APSU, my lord. APSU Honorable Pradesh Students Union, my lord. But unfortunately, my lord, in the pleadings, my lord, the entire abatement has been made against the APSU, but the APSU has not been made as a party, my lord. So therefore, my lord,
That's right.
You raised the point.
That's why,
My lord.
maintenance with you, wait.
You raised the point on non-joiner of necessary party.
my lord, development.
Item number 4.
May I
This
please,
one.
my lord? Yes, my lord.
Okay.
My lord, I am appearing on behalf of the appellant who has been convicted by the learned special judge Pokso, my lord.
You are Mr. Sonar.
B. Nyarus.
P.
Nyarus, my lord.
Diloi, learned additional public prosecutor for the
PP, Lord.
respondent state.
PP, lordship.
Okay, learned public prosecutor for the respondent state. Respondent number 1, comma, state of ownership. Under section 415, Bharatiya Nagarik Surakha Hanika is directed against a judgment dated 3/3/2026 and an order on sentence dated 11/3/2026 passed in POXO case number passed by the Court of Learned Special Judge POXO UPA in POXO case number 21/2021, arising out of Itanagar Women Police Station,
Yes, my lord.
case number 41/2020, post up. By the judgment and order on sentence, the petitioner, accused appellant has been convicted for the offences under section 376(2)(f) Indian Penal Code and section 6 POXO Act, and in view of section 42 POXO Act, the petitioner accused appellant has been sentenced to undergo rigorous imprisonment for 20 years and to pay a fine of rupees 20,000, which defaults to gone through the grounds urged in the memorandum of appeal. The criminal appeal is admitted for a hearing. The trial court request be called for issue notice returnable on so and so, give a date after 4 weeks. As Mr. Lawyer has when additional public, tolerant public prosecutor has appeared and accepted notice on behalf of the respondent number 1, State of Arunachal Pradesh, issuance of formal notice to the respondent number 1 is not necessary. Extra copy of the memo and along with an extra. Within 2 working days from today, the accused appellants shall take steps for service of notice upon the respondent number 2 by speed post within, through the PP, to the PP. And routed through the PP, and PP will obtain a service report from the officer in charge, Itanagar Women Police Station.
Much obliged.
21 May. Item number 6.
Wait, please, Your Lordship.
Yes.
My lord, this writ appeal is filed against the order dated 7/4/2026 passed by the learned single judge, whereby the interim prayer of the petitioner was not allowed, my lord. This writ appeal is basically against the rejection of the interim prayer. Page 53 is the impugned order, my lord. 5-3. What had happened in this case, my lord?
Let us,
My lord,
just read the
page 53. May I read it?
19.
Last 14 years.
Yes.
My lord, since the matter is fixed on 5th of next month, my lord, it's only a matter of 14 days, my lord, because in the meantime, if he joins, my lord, it might disturb my lord, it might create some problem, my lord. And moreover, my lord, the present petitioner is holding the substantive post of district level, district food and civil supplies officer, which is a
What is the distance between Pasighat and Rowing?
Pasighat and Rowing would be 100 kilometers? 150 kilometers approximately.
Change of place is necessary
No, my lord,
after 14 years.
no, my lord, that 14 years is factually wrong, my lord. It is not 14 years, it is 12 years.
Good enough.
My lord, what I'm saying is that, my lord, he has, in fact, the appellant had foregone his promotion for the purpose of looking after his 80 years old father. Even I'll just indicate one page, my lord. He was promoted. He has even given up his promotion. So that, my lord, may kindly come to.
But that does not change.
I
That
understand.
transfer is an incidence of service.
Incidence of service, my lord. I
That
understand.
will not change.
I understand. I have also made a representation before them, my lord. They are not even considering.
What is the law regarding representation?
My lord, representation.
What is the condition precedent?
My lord, he must have a right to exist or such.
No, what is the condition precedent for submission of a representation against the transfer order?
That he will have to go and join and then make.
Yes.
No, my lord, those are there, but my lord, there are, my lord, instances where, my lord, even without.
What is the road condition?
My lord, it has been long time I have personally visited. Road condition, my friend would perhaps be able to say better, my lord. But, and moreover, my lord, he is being replaced replaced by
That submission is evasive.
that. No, my lord. The road conditions, my lord, honestly speaking, I don't have any knowledge regarding the road conditions.
Petitioner has the knowledge.
Road condition, yes.
He must have inquired with the petitioner.
No, my lord, the road condition, I am told that it is not, I mean, it is okay. The road
It is
condition is
So what is the traveling time?
traveling time would be around 2.5 hours, my lord.
2 hours.
2 hours, 2 hours going, 2 hours coming, my lord. My lord, be that as it may, my lord, my only submission is that, moreover, my lord, the person who is sought to be replaced by him is a much junior, not only in terms of length of service, he also belonged to a lower cadre, Group B.
Supreme Court says one
In
should
charge.
be placed at one place for a longer period. Otherwise, like a big tree, it has a person gets his roots implanted in the place.
My lord, if nothing has happened for last 12 years, nothing will happen for another 2 years, my lord. If not,
No,
If for last 12 years-
your intention is for 2 years.
yes, 2 years, that is what I said, my lord. If nothing has happened for 12 years, my lord, I don't think anything will happen in next 2 years, my lord. So at least a status quo till 5th, my lord.
We don't find any infirmity in the order.
Only in status quo till 5th, my lord. Let the single,
Status quo,
let the,
a suspension, everything is same
my lord, let
in a
the,
matter of transfer.
at the end of the day, my lord, let the single judge take a call on the writ petition, my lord. At least,
Let the single just
because
take
in
a
the-
call.
because in the meantime, my lord, if he comes and joins, my lord,
If you are not, the person has not joined or any unilateral order to join unilaterally has not been passed in the meantime, you continue with the writ petition. What is the returnable date?
5th of next month, my lord. It's only a matter of 14 days, my lord. Because I am told, my lord, yesterday he got the private respondent has been released from his
12
post.
years is too long. 12 years is too long.
Only another 2 years, and my lord, he has to take, because my lord, he has even given up his promotion, my lord. May kindly see page
That
56.
is a different
Page
matter.
56 for a while.
That will not dilute the position that transfer is an incidence of service, and in case of administrative exigence.
And moreover, my lord,
And
there is a letter.
it is the employer who is in best position to
Now-
place officers,
My lord,
unless malafide is
my lord,
established.
there is one more aspect, my lord. Here, the transfer is at the behest of the member of parliament, my
That
lord.
has been taken care of.
The member, which is why, my lord, I have come before this honorable division bench, my lord.
Where
Because
is the letter?
my lord, your letter, your lordship will see page number 51.
They may write so.
My lord,
There is a provision. And they can.
a officer who has worked under me at one point of time is now replacing my, I'll have to give charge to him now, my lord. That's,
Is it below your dignity or what?
no, my lord, it's there, it will
You are
also,
an employee of the state.
absolutely, my lord. But it will also set a precedent that junior and officers from Group B post can take over, can be transferred in substantive Group A
Is
post.
your position been changed?
No, my position is not changed. No,
Rank and status has been
no,
changed.
my position is not
Then-
changed. My lord, may kindly,
It is, no, Mr. Vishwas. We don't find anything.
Till 5th, my lord. Otherwise, the writ petition, my lord.
No, we don't find anything to interfere. Heart. Mr. M. Biswas. You urge referral on a single judge.
Lord, by then, that's the difficulty is that by then he will come and join, my lord, and I'll be forced to go and.
There is no representation
There is a that is what I've said, my lord. At least let them.
sitting in Pasighat.
At-
By sitting in Pasighat, learned counsel for the appellant, writ appellant. I think there is a recent judgment of from Arunachal Pradesh by the Supreme Court of India also, apart from Mohammed Masood. Writing letters by the
MLA and the MPs. Provided it
and
is made in.
single judge has observed that was way back.
But they are continuously pursuing that, my lord.
Which for a state? Miss Learned State Council for the respondent number 1, 2, and 3.
Lordship, I'm for 2 and 3 on behalf of Tijambo Lordship.
Mr.
Standing Council, Ketabang Lordship. On behalf of Tijambo Lordship.
Learned Council on behalf of Mr. T. Jamo.
Tijambo.
Learned Standing Council.
For, yes, Lordship.
Food
Food and
and
Civil
Civil
Supply.
Supplies Department, Government of Arunachal Pradesh. Post para this intra-court appeal is directed. What is that order? What is the impugn order?
53.
Against an order dated 7/4/2026, passed by learned single judge in a writ petition WPC number 153/2026. Post up. The writ petition is preferred by the writ appellant as the writ petitioner to assail an order dated 19/3/2026, whereby he has been transferred from Pasighat to Rowing. Full stop. The petitioner is presently serving as the
District food
and
civil supplies.
civil supplies officer. Full stop. By order dated 7/4/2026, the single judge, while issuing notice returnable on, making the notice returnable on 5/5/2026, has also heard on the interim prayer. Full stop. After hearing the learned counsel for the parties, learned counsel for the writ petition and the learned state counsel, the learned single judge has declined to extend any interim relief sought for on behalf of the writ petitioner in the form of suspension of the impugn order dated 19/3/2026. Post of para. By the order dated 19/3/2026, comma, the department, the respondent, issued under the hand of the respondent number comma, three incumbents holding the post of District Food and Civil Supplies Officer, within bracket DFCSO stroke Subdivisional Food and Civil Supplies Officer as the FCSO have been transferred post of the petitioner who is serving as DFCSO has been transferred from Pasighat to Rowing, and in his place, the respondent number 4, A SDFCSO and in charge, DFSO has been transferred from Anini to Pasighat. Post of. Mr. Biswas, learned counsel for the appellant, has submitted that during the course of his service, the petitioner had foregone a promotional opportunity in order to remain in Pasighat as the petitioner, as the appellant has an ailing,
80 years old.
as an ailing parent or father or what?
Father.
As an ailing father of 80 years of age. Full stop. It is his submission that the petitioner is required to attend his ailing father, and in that connection, the petitioner has already submitted a representation before the competent authority. Full stop. The said representation has not yet been given consideration. Full stop. He has further submitted that the respondent number 4, who has been transferred in the place of the appellant, is an officer who is in the FIDA cadre and much junior to the appellant.
Group B, in fact.
Full stop. The respondent number 4 is only serving as in charge DFCSO, and his substantive rank is in a cadre. In substantive rank is as the FCSO. Full stop. To support, he has further contended that the elected representatives from Pasighat area, the transfer order has been effected at the behest of elected representatives of Pasighat area. And it was the matter was pursued. matter, the matter of, the request for transfer was pursued by the elected representatives since long. Full stop. Para. The learned single judge has observed that the petitioner, appellant has been posted at Pasighat for the last 14 years, whereas the respondent number 4 has spent about 3 years at Anini, wherefrom he has been transferred to Pasighat by the impugned order dated 19/3/2026. Mr. Biswas has submitted that the petitioner is posted at Pasighat for about 12 years. Full stop. But on a query made by the court, Mr. Biswas has submitted that the distance between
Rowing and Pasighat.
Pasighat and Rowing is about 100 kilometers.
150.
100 kilometers.
100, no?
Oh, 100 kilometers. Full stop. It is settled that transfer is an incident of service, and it is the employer who is in best position to decide to place officers stroke employees at places. Full stop. The learned single judge has found that the elected representatives made a request for transfer the respondent number 4 about a year ago, and the same would not be relevant to decide in a matter of transfer which are affected in administrative exigency. Full stop. The respondent number 4 has been serving as in charge DFCSO from a date anterior to 19/3/2026, though he is in the substantive rank of SDFCSO. Full stop. The nothing has been submitted as regards violation of any statutory rules or nor there is any allegation of malafide. Full stop. having regard to the settled propositions of law in a matter of transfer, we do not find any infirmity in the order dated 7/4/2026. No, any infirmity in our observations made by the learned single judge in the order, in the observations, albeit tentative, passed by the learned single judge. In the order dated so passed by the learned single judge. Full stop. As a consequence, we do not find any merit to interfere with the order dated 7/4/2026. And as a result, this inter-court appeal fails. Full stop. It is therefore dismissed. Full stop. It is, however, observed that the observations made herein above shall not be constitute, are only for the purpose of only for the purpose of testing the legality and validity of the interim order dated so and so, and same shall not be constituted as observations as regards merits of the repetition.
Item number 7.
My lordship.
Yes.
This is, lordship, this appeal is against the single judge order, lordship.
Order. Which
Judgment,
page?
lordship.
Judge-
Page, yes, page number. Come on, ma'am.
Page the judgment.
Order, not judgment, lordship. Page number 69 and 70, lordship.
16, 16, 17.
It's 13 only.
Lordship, this is something defect in
Page
the
14.
petition.
Page 14.
Start from page 13.
It is,
Okay, page 13.
Start from page 13.
yes, yeah.
Yes.
This is,
Yes, please.
this is, may I, lordship, adjourn the matter, lordship. This is wrong.
Hmm?
This is previous order has been closed, lordship.
Page 13 में
Page 13.
impugn order है.
No, page 13 है क्या? Oh, yes, page 13.
Yes.
13, na?
138.
30.
Yes. And order dated 14/7/2025 was challenged, right?
Yes.
Where is that order? 14/7/2025.
Page 13.
Page
Page 13.
10.
1 3.
13.
13. 13 is the impugned judgment.
Is the impugn judgment.
No, in the writ petition, an order dated 14/7/2025 was challenged.
Yes.
Where is that order?
Yes.
Is it
Lord,
part of the
there is-
writ petition?
There is a lordship, there is a
Part of the
defect.
writ petition?
Yes. There is a defect in the matter may be listed for tomorrow, lordship. There is a defect in my page.
Defect?
Yes, defect. Maybe fixed for tomorrow, lordship.
Day after tomorrow then?
Day after tomorrow.
Okay, on the
In that
request
case,
of-
Los, just I would like to point out, Los, even our affidavit also has not been.
Oh.
So I think
Affidavit
it's
should be
better,
part of the writ appeal.
Yes. I will file.
better to withdraw and then file.
No,
You
Lordship,
can file tomorrow.
additional file, Lord, additional.
No, no,
What is just,
you file it comprehensively.
additional affidavit.
Anyway, if you make a, it will be listed day after tomorrow.
Additional, day after
Make a mention.
additional.
Okay. Which one? Withdraw.
No, not with,
file
Lordship.
fresh.
I will file affidavit, additional affidavit.
Also. On the request
The
of
document.
Mr. T. Tapak, learned counsel for the appellant, release the case on day after tomorrow.
Petition भी पूरा नहीं है.
Item number 9.
Senior government.
Mr. S. Tapin, learned senior government advocate for the state respondents, is in attendance.
May I apply me also?
No hold.
My lord,
In this matter, my lord,
Yes.
respondent number 3 is yet to file counter affidavit and they have taken on, your lordship may see the order.
Respondent number 3.
Yes, 212.
Petition Control Board.
Yes, my lord.
Okay. What is the
212.
matter about?
Yes, my lord.
What is the matter about?
My lord, matter related to the violation of stone crusher guidelines of 2002 Allahabad.
Then Pollution Control Board is a party
Yes, my lord.
which needs to respond.
Yes.
yes, my lord, affidavit in opposition has been prepared and sent for vetting.
Okay. So there is some advancement.
Yes, my lord. They have taken on 212, 9th January and 24 February.
Now draft has been prepared and
Yes, my
sent
lord.
for vetting.
So make sure that, my
How
lord.
much time you need?
3 weeks, my lord.
3 weeks.
Yes.
It will be vetted so scrupulously. Okay. Mr. S. Mo. Heard Mr. S. Mo, learned counsel for the petitioner. Mr. Tapin, you appear for state. Oh, sorry, N. Ratan. Mr. N. Ratan, learned additional advocate general for the state respondents. Miss. Mr. Patin, you are.
Yes, respondent number 10.
Okay, Mr. T. Patin, learned counsel for the respondent number 10. Miss. Learned standing counsel.
Not yet, my lord.
Learned counsel for the respondent number 3, comma. Arunachal Pradesh State Pollution Control Board has submitted that the draft affidavit on behalf of the respondent number 3 has been sent for vetting. And if the case is posted after 3 weeks, the affidavit, the counter affidavit on behalf of the respondent number 3 will be filed. She has the sought for listing of the case after 3 weeks. A prayer made on behalf of the respondent, as the counter affidavit on behalf of the respondent number 3 is necessary for adjudication of the issues raised in this PIL. The prayer is allowed. Release the case on after 3 weeks. Give it
14.5.
14.5. Number 3 is to ensure that its counter affidavit is filed on or before 14/5/2026.
Item number 11.
Please, Lordship. Lordship, I am the legal aid counsel.
Yes.
There is a delay of 145 days.
And you have not filed the application.
For that, I have said the convict is at Teju jail. On 6th, I have, through this High Court Legal Service Committee, I have submitted the application on 6th.
You are expecting?
Yes, expecting.
To receive the signed application?
Yes.
So
Lordship, normally the delay was condoned in jail, Lordship.
Obviously, but application has to be there.
Yes, Lordship, there is a different opinion, Lordship.
earlier in this coordinate bench, division bench lordship find that there should be application for delay and preparation of a memorandum of appeal lordship. But on the last occasion, his lordship, SK Medi and Justice, Honorable Justice K. at the lordship is of the opinion that in the jail appeal, memorandum of appeal is not required, lordship.
Has it been, any order has been passed to that effect?
Passed.
None of opinion, just a fine, lordship.
But there has to be an application, otherwise
Yes,
no requirement of the Limitation Act.
Yes.
Has not that schedule of the CRPC or BNSS
Yes, lordship.
or Limitation Act
Yes, lordship.
has not differentiated between an appeal preferred by a private counsel
Yes.
and a jail appeal.
Yes. In that lordship, he may be able to file, lordship.
Otherwise, condonation of delay is not the issue, but
Yes,
it has to be as per the procedure. only.
Yes, lordship. I just phrased the lordship opinion, lordship.
Should be.
Okay, Mr. U. Bori, Learned Legal Aid Counsel, has submitted that he has not yet received but condonation application could be filed by the Legal Aid Counsel or what? Could have been filed. Could have been filed because he received it late. Say he received it late from the legal services authority. So in the meantime, delay has occurred. It could have been filed, but I think application needs to be filed. Because I have seen many tax matters and appeal also, criminal appeal also. Yeah, application is generally there. Yes, we condone the delay. It is different. Is there any view for forming that view? There is something difficult to get that certified. Okay. Okay. He has submitted that he has not yet received a signed copy of the application seeking condonation of delay. First of, he has therefore prayed for listing of the case after 2 weeks.
Okay.
2 weeks. First of, Mr. D. Loy,
D. Loy,
learned public prosecutor for the state, is present. In view of the reason cited by Mr. Bori, list the case on strength. 2 weeks.
7-5.
Highly.
Item number 12.
Lordship, in this matter, Lordship, I've been appointed as the legal aid counsel, Lordship. So I have
issue notice. Okay. You are Miss J. Ginny.
Correct.
Mr. J. Ginny.
Correct.
Heard Mr. J. Ginny, learned counsel, learned legal aid counsel
Correct.
for the appellant, accused appellant, Mr. D. Loy, learned public prosecutor for the respondent state. 302.
No, Lordship.
And
7 years in prison.
20 years.
is admitted for hearing.
20 years.
As the TCR has been received, the registry to prepare the paper book. Release the case after 4 weeks for a report as regards preparation of the paper book.
Published.
26.
26. You don't need no. I've seen one order. Legal counsel was asked to prepare them more. So that who has passed in order to file the memo. And then you have to do it.
Item number 13.
Milods, in this matter, I am appearing for the petitioner, Milods. White Milods, the last
Yes.
order dated 19th of March 2026, your lordship had allowed the petitioner to effect dusty service, Milods, on respondents number 1 and 2. Milods, that has been done and an affidavit of service dated 7th April 2026 has been filed.
Yes. We'll accept. Right. Normally, normally what we do is we draft it and send it to the lawyer. Look into it. That's not possible. We have lawyer code here. Okay, then we'll accept. We will sign. Third, Mr.
Milods, Aditya Shankar.
Your good name, please.
Mr. Aditya Shankar Pandey, Milods. Aditya Shankar.
Yes, Pandey, learned counsel for the petitioners through the virtual mode, and Miss
T. Wangmo.
E. Wangmo, learned permanent advocate, Arunachal Pradesh.
What is
So
phone
that's
number
fine,
3?
number 3.
Yes.
4 is not there.
The 4 is also
Department
government
of
Arunachal Pradesh.
Government Advocate, Government of
Yes.
Department of Education.
There's a standing council, my lord.
Who is the standing counsel? Because
Tagum Jamo Maris,
Uh-huh.
absent today.
he should be served. Minus is insurance. Okay. Notice. Petitioner was asked to take steps for service of notice having response number 4 by registered post. Order 29/7/2025.
Yes.
If we have a standing counsel and
Yes.
huh? Yes, Mr. Sir,
Yes, Milods.
have you taken any steps for service of notice having the response number 4?
Milods, to my instructions,
Credit
they.
card received. Okay.
Yes, Milods.
Yes. They have a standing counsel,
Milods.
right? You can serve a copy upon the
Milods,
standing counsel.
we'll survey
Okay.
on this.
By order dated 19/3/2026, the petitioners were permitted to effect service of notice upon the response number 1 and 2 by way of dusty and to file a compliance affidavit to that effect. Full stop. An affidavit of service of notice has been filed on behalf of the petitioner. Full stop. We have gone through the statements and amendments made in the affidavit and have perused Annexer 1 and Annexer 2 there of full stop. It is averred that notices have been duly served upon the respondent number 1 and the respondent number 2 on 30/3/2026, and receipt of the notice was duly acknowledged under seal and signature by the respondent number 1 and the respondent number 2. Full stop. Having considered the same, the service of notice upon the respondent number 1 and the respondent number 2 is treated to be complete. Full stop. It is informed at the bar that the Department of Education, Government of Arunachal Pradesh, has a standing counsel. Mr.
Tagum Jamu.
Tabung
Tagum Jamu. T Jamu, man.
T. Jamu. Post of learned counsel for the petitioner shall furnish a copy of the petition along with annex to Mr. So learned standing counsel, Education Department.
T Jamor, T Taba.
T Jamu. For higher education, my lord. T Jamu.
Jamor. Okay. Higher Education. Higher Education Department.
Yes, ma'am.
T. Jamur, Learned Standing Council, Higher Education Department, within 3 working days from today.
Yes, my lord.
Okay. Lays the case on.
My lords, I am requesting for a fixed date, my lords, if it is possible, my lords, after 2 weeks.
Yes, yes.
Yes, my lord.
Lays the case on. Okay. Give it in 4 weeks. May. Today is 21st. 19th of May.
My lords. Highly obliged.
Item number 14.
May I please, Your Lordship?
Yes.
Your Lordship, this matter is regarding the irregularities and misuse of.
But we have to await for service report.
Your Lordship, I have make a prayer. Your Lordship. After the filing of this petition, the subsequent development has been taken place, Your Lordship, and because of that, and we have the petitioner has obtained the information through the RTI, and also which has brought new facts, new material before on record, Your Lordship. So, on view of this subsequent development, Your Lordship, I pray, and with the due permission of this honorable court, would like to, if permit, would like to withdraw the petition and within the and with liberty to file fresh within the period of 10 days.
Yeah. Yeah.
What do you say?
But bill can be, it is not so much. Miss
D. Mema.
P. Heard Miss T. Mema, Learned Counsel for the petitioners, and Miss So-and-so, Learned State Counsel for the state respondents. Miss So-and-so has submitted that the petitioners during the subsequent petition period, the petitioners have received some more materials which would have a bearing which should be of relevance. Post of Ms. So-and-so has submitted on instruction that the petitioners want to withdraw this petition with a liberty to file afresh with detailed particulars. Post of Ms. Swensel and State Council has not objected to the prayer for withdrawal in view of the above submission made by so-and-so. Learned Counsel for the petitioners. This petition is dismissed on withdrawal with the liberty as paid for.
Deeply obliged.
Over. Okay.
My lord,
Yes.
I beg to mention item number 7. My lord, in this case, the respondents has filed their affidavit. I may be given an opportunity to file my rejoinder and fix this case for hearing, my lord.
Mr. T. Patil, Learned Counsel for the petitioner, has sought for and is granted how much time you need?
4 weeks time.
4 weeks time to file an affidavit in reply to the affidavit in opposition filed by the state respondent.
By the respondents.
Filed by the respondents.
State also, NSPC also.
Okay. Affidavits in reply. To the affidavit in opposition, affidavits in opposition filed by the state respondents and the private respondents. Okay, release the case on friends.
My lord, item number 8. Lord, item number 8 is pertaining to some wrong calculation of the compensation alignment. Respondents, they file their affidavit. May I present this, maybe listed day after tomorrow for an attempt to make for disposal.
Okay, on the request of Mr. T. Patil, Learned Counsel for the petitioner, release the case day after tomorrow. Huh?
And then my lord, item number 10, respondent number 4 has filed an affidavit, but the copy has not been served to me. My lord, in case of serving the copy, I may be given an opportunity to file my reply, my lord.
Respondent number 10.
10.
Who
Case
appeals
number
for
10.
respondent number 10?
No, respondent number 4.
Respondent number 4. State? Respondent number 4 is state or what? File.
Yes, Deputy Commissioner.
File.
Item number 10.
10.
10.
10.
You here, huh? Never file is prepared. Deputy Commissioner.
Deputy Commissioner.
Deputy Commissioner. Yes, a copy is to be served upon the petitioner. Okay. Mr. R.
Wairam.
Why? Learned, Mr. T. Patil, Learned Counsel for the petition is present. And he has submitted. Mr. T. Patil, Learned Counsel for the petition has submitted that he has not yet received a copy of the affidavit in opposition filed on behalf of the respondent number 4. So Mr. So-and-so, Learned, your main advocate, has submitted that he will furnish a copy of the affidavit in opposition of the respondent number 4 to the Learned Counsel for the petitioner within 2 working days from today. Post-op. Mr. Patil has submitted, in response, Mr. Patil has submitted that if a copy is furnished to him, he would need how much time?
4 weeks.
4 weeks time to file an affidavit in reply to the said affidavit in opposition, if so advised. Post-op. He has thus sought for listing of the case after 4 weeks. Release the case. A prayer is allowed. Release the case on suit.
An interim order earlier passed.
The interim order passed earlier shall continue till the next date of listing.
My lord.
Yes.
You mentioned the item number 12.
12. File.
Appearing on behalf of L. Karme.
For respondent number?
Respondent number 1, 2, and 4, my lord.
1, 2, and 4. Yes?
My lord, pleadings are completed. The matter may be released for admission.
Who is for the petitioner?
Yes, my lord. I am for the petition, my lord.
Training is complete.
Pleadings is complete, my lord. It may be fixed for admission hearing, my lord.
Okay.
On, my lord, 4th of May, my lord.
Learned Mr. So-and-so, learned counsel for the petitioner. Mr. So-and-so, learned government advocate for the state respondents. And Mr. So-and-so, learned counsel for the respondent number 1, 2, and 4.
4.
Have submitted that the exchange of pleading is complete. Full stop. In view of the above submission, let the case be listed on so-and-so in an admission column.
Yes, ma'am. 4th of May, ma'am.
In the admission column.
Yes, ma'am. All right.
May I, Your Lordship?
Yes.
Your Lordship, I beg to mention item number 15.
1-5.
Yes, Your Lordship.
Yes.
I'm appearing on behalf of Mr. M. Kato.
On behalf of?
M. Kato, Your Lordship. DSCI, Mr.
Oh,
M. Kato.
yes. Oh, yes. Adjournment.
Yes, Your Lordship. 2 weeks may be given.
You have informed the petitioner?
Yes, Your Lordship.
Okay. Mr.
Meto, Your Lordship.
Learned counsel on behalf of Mr. M. Kato, learned DYSZY. For all the respondents.
Yes, Your Lordship.
Has made a prayer for adjournment. So it is submitted that consent has been taken from the learned counsel for the petitioner to make the prayer. As sought for. List the case after 2 weeks on a date to be fixed by the office.
Much obliged.
Item number 1.
May I please, Your Lordship?
Yes.
Well, this is a Section 11 petition. We are seeking appointment of an arbitrator.
Okay.
The petitioner is a energy trader, had signed an agreement with the Department of Power, Government of Arunachal Pradesh in 2011. That agreement, my lords, was terminated unlawfully. And
when?
My lords, this termination of the agreement took place on 2/8/2011, which your lordships would find at page 57.
Limitation will not come in.
My lords, I'll explain how. The company.
57.
Yes, my lords. The company went into insolvency, my lords. My lords, may kindly have page 57 for a moment.
Terminated. Cancel.
Yes.
Well, issue notice at this stage.
Yes, sir.
Issue of limitation is kept open for consideration. You have to explain.
Yes.
I
Heard-
responded, my lord.
Huh?
I put responded, my lord. Sole respondent.
Heard Mr.
C. Garg, my lords.
C. Garg, learned counsel for the petition. And Mr.
T. Role.
T. Dore,
Yes.
learned government advocate.
No, my lord. I am appearing on behalf of Standing Counsel El Parme.
On learned counsel on behalf of Mr.
El Parme.
L. Parme,
Yes.
learned standing counsel, Power Department,
Yes, my lord.
Government of Arunachal Pradesh. First up, this is an application under Section 11 of the Arbitration and Conciliation Act 1996, seeking appointment of an arbitrator. First up, there was a power purchase agreement between the petitioner and the Power Department, Government of Arunachal Pradesh.
Dated 14/7/2011, my lords.
14/7/2021.
2011, my lords.
And by an order dated 2/8/2011, the said power purchase agreement has been cancelled. Full stop. The appointment of arbitrator has been sought for in terms of clause,
Plus clause 11 of the PPA,
which page?
which your lordships will find it in the additional affidavit, your lordships, page number 274, clause 11, resolution of dispute.
Clause 11 of the power purchase agreement. First of para, Mr. Soyan Surland counsel on behalf of the respondent has raised an issue of maintainability of the petition on the ground of limitation. First of matter would require consideration, issue notice returnable on so and so. After 4 weeks, give a date. As Mr. So and so has appeared and accepted notice on behalf of the sole respondent. Issuance of formal notice to the respondent is dispensed with. Extra copy of the petition, along with annexer and the additional affidavit. Copy of additional affidavit are to be furnished to the Lands Council for the respondent within 3 working days from today. The issue of maintainability is kept open on the point of limitation raised by the respondent is kept open for consideration at an appropriate stage.
Deeply obliged, your lordships.
Item number 2, 19.5. 19.5. 5.
May I please, my lord?
Yes.
My lord, this application has been filed for willful disobedience.
Which
and
order?
non-compliance. My lord, annexure 2, page number 17, my lord.
Page number 17.
And the operative part would be at page number 21, my lord. Paragraph 7.
Heard Mr.
J. Sring.
J. Sring, learned counsel for the petitioners. This contempt petition is filed alleging non-compliance of the direction made in an order dated 23/7/2025 past in a writ petition. WBC number 327/2025. It is averred that the order dated 23/7/2025 has been duly brought to the notice of the respondents
on
28/7/2025.
1/8/2025.
On 1/8/2025. Post of issue notice returnable on so and so. After 4 weeks, the petitioner shall take steps for service of notice upon the respondent by speed post within 2 working days from today.
Grateful.
Item number 3.
My lordship, this matters already admitted
Oh,
and the government has
Affidavit
to
of
file,
appointment.
yes.
My lord, I have different proposal, my lord.
Okay.
The lordship is able in transparent posting, my lord. In SL Abel case, it has been reiterated once again, my lord. These are the incident service, my lord. There is no any malafide alleged, my lord. Only what they are saying is frequent transfer, my lord. Now, my lord.
Interim order.
Yes.
Yeah, status quo order is there because, my lord, Shepherd said because there is no reliever, my lord. Now, my lord, representation is pending, my lord. It's a pending before the authority, my lord. So my lord proposal is that, my lord, till representation is disposed of, status quo may be continued, my lord. We don't have any objection, my lord. Because keeping pending here will not survive, my lord. It will not.
My lordship, we don't want to dispose in the department, as I said last time also. So we want to continue. We want that reply.
Continue with the, my lord, status quo order, my lord.
There is interim which may be continued, and we are not okay with the.
That will not serve the purpose, my lord. The question is public interest because he was transferred to back and forth, my lord. Now there is no officer. That is the most important, my lord.
Lastly, he has been transferred to people
My lord,
to resign in an existing vacancy.
Transfer order is,
Has
my
not
lord.
been released.
Page 19, my lord, this is the impugn order.
Right. Let us see. So, transfer from facility, region project. Where is the impugn order?
My lord, page 19, my lord, annexure 1, my lord. Petitioner is real number 3, my lord. Pipu subdivision to Pezaran subdivision against existing vacancy, my lord. So right now, my lord, in this subdivision, my lord, there is no officer, my lord.
It is 9 September 2025.
Yes, my lord. My lord, down, my lord, is 15 September, my lord, although it's on top is 9, my lord, but signed on 15 September, my lord.
Type 3. You can get some written instruction.
Yes, that's
instead
right.
of affidavit that this vacancy is required for administrative purpose. Because see, I have to. This is of September.
Correct, my lord.
2025.
25.
After 6 months,
They filed the
they filed a writ petition.
Correct, my lord.
And the coordinate bench has passed an order of status quo.
My lord.
And till filing of the affidavit in opposition.
My lord, do we agree? Because my lord,
we can keep this affidavit in opposition in the form of written instruction also, right? But I'll not bypass that. You get the.
But
get
why, my lord, the petitioner, my lord, since they have submitted the representation, my lord, why they are, my lord, apprehending that adverse order will be passed, my lord?
Right. There is no application for vacation of the interim order.
My lord.
No affidavit in opposition.
My lord.
At least some written instruction.
Whether, my lord, that Pijarang subdivision require any officer or not, my lord. That part, my lord, yes, we can, my lord.
Then only we can. Otherwise, see, I have to go by the coordinate bench order. After 6 months, this status quo has been passed.
My lord,
You have not released him.
my lord, reason behind, my lord, there is no reliever, my lord. Because of that only, my lord, yes.
But you could have released him. You did not release him.
My lord.
For 6 months. Then he prepared the writ petition. So give something tangible for the court to work on it. See,
My lord,
order was
my lord.
order
What
was
he
in
wants to do, my lord, yes.
Huh? Order was in September
Very
2025
my lord.
against an existing vacancy, and there was no reliever also.
My lord.
Right, that post is vacant at Diun. Oh, sorry.
Pijarang, my lord.
Pijirang.
My-
Pijirang is vacant.
My lord.
And in Pipu, this man is holding the position.
Still continuing.
Right.
My lord.
Because there is no reliever.
My lord.
Then if it was of such administrative exigency, you could have released him. You did not release him. 6 months he was there. Thereafter he chose to prepare the writ petition. Right.
My lord.
In March. In March he prepared the writ petition. And thereafter after next date, on the next date,
No, first day, my lord.
first day, you were asked to obtain instruction.
Correct, my lord.
Right. Then on 18, this interim order has been passed.
Correct, my lord. Correct, my lord.
So if you require him at Pijirang and not Pipu, get some instruction.
My lord.
In the form of writing so that the court can work on it. Otherwise, just by the saying, it will not be possible. What is your frequent case of frequent transfer? Tell me.
Yeah, this is the fourth.
How?
time.
There is that of officers or what?
My lord, there is, my lord, why I'm
See,
saying,
there can be dart of officers
my lord,
to fill up the post of assistant engineer.
my lord,
Say there may be 100 posts, but there are only 70
my lord,
assistant engineers.
but my lord, of the record, my lord, there is, because of my lord, series of litigation, we are yet to finalize a seniority position. And because of that, we are not able to give regular promotion. Now, if you give them officiating also, my lord, regular they say, my lord, he's not equally status, my lord. You cannot replace me, my lord. That's sort of problem we are facing.
Whatever something is,
My lord, yes, welcome.
get it on Friday.
My lord.
Then we can, protecting his interests also, we can pass an order for disposal of the representation. His case will be highlighted and according on your issues, why you require him as PG rank, can be highlighted and thereafter we can dispose it off. Because he is saying about frequent transfers. When can you get it?
Friday or Monday, my lord. Your lordship will be
Friday?
here.
Okay.
Friday we can try, my lord, if not Monday.
We'll post it on Friday.
My lord, very well.
Okay.
Okay, much.
Miss so-and-so. Learned counsel for the petition is present. Mr. R.H. Nawab, learned additional advocate general, has shortlisting of the case on Friday in order to enable him to make an endeavor to get written instructions in the matter.
My lord.
List the case on so-and-so. Friday, the interim order passed Friday shall continue. Interim order of status quo.
Status quo, my lord, yes.
The status quo order passed on 18/3/2026 shall continue in the meantime.
My lord. Let's have.
Item number 4.
Lordship, through this writ petition, we are all regularized assistant engineers, Lordship. We are challenging the DPC and subsequent provisional seniority list. Lordship, background of the case, Lordship, may kindly come to page number 175, Lordship.
175.
Lordship. Entire background of the case is highlighted here, Lordship. So I am, I'll take the reference of this particular documents.
Okay. What is this background?
Background. So what had happened is, Lordship, there was a vacancy of 23 posts of AEs, Lordship.
Vacancy of assistant engineer.
Assistant engineer. They are serving as JE, Lordship. Before that, they were appointed as ad hoc in several AE posts, Lordship. Lordship will see.
Okay, let us read then.
Lordship.
Let us continue, then I'll understand.
Correct. On ground of administrative urgency, the following mentions 23 junior engineers who were the senior most amongst the serving JEs of PHE and WS were appointed to the post of AE on ad hoc basis on varying dates with full financial and other benefits as applicable. The details are given below. Now, Lordship will see date of regularization in the left side of the column, Lordship, or right side of the column. Date of ad hoc appointment as AE. They were in the year 2006, 2007, 9, 10, 11, 14, 15.
14.
Yes.
15.
So many dates are there where they are ad hoc.
And these petitioners are among these 23.
Yes, correct. Lordship.
Okay.
19, 20, 21, 22, and 23 are the petitioners, Lordship.
19,
20, 21, 22, and 23.
Total 5.
One more is there, 12 also, Lordship.
12.
12 also.
Okay. They were ad hoc assistant engineer 2011 and one is from 2011.
Correct, Lordship.
The other is from 2015.
The rest is from 2015. Now, Lordship may kindly
all joined
also
in
note.
all joined in 1996.
Correct, Lordship. That date in the previous column is it's clearly reflected, Lordship.
Yes.
Now, the private respondents are, Lordship, serial number 11, 13, 14, 15, and 17.
11,
13, 14, 15, 17, and 18, Lordship.
15, 17, and 18.
Correct.
Yes.
Now, as per this notification, Lordship, they were
Let us.
they are serving ad hoc AEs, Lordship.
Okay.
Now, in order to regularize their post, DPC was conducted. Lordship will see in the subsequent paragraph 2. To regularize the ad hoc service of the above AEs as DPC was conducted, Lordship, in the year 7/9/2020, Lordship. Out of 22 AEs, the DPC considered to regularize ad hoc services of 16 AEs from prospective date, that is 7/9/2020. The date of DPC annexures A, the name of the officers are listed below. Out of 22, Lordship, 16 were considered in the year 2022 for regularization of the AEs, Lordship. Now that remaining 6, they were the respondent who in this writ petitions, Lordship. Their case was not considered in the year 2020, Lordship. They were left out, Lordship. The reason is, Lordship may kindly come to page.
Just a minute. 1, 2.
The reason why they were not considered, Lordship, that is not very.
Yes.
It's not clearly reflected in that paragraph.
Cases of following 6 ad hoc A's for a region given in remarks and decided to consider cases as and when required documents are submitted.
They failed to submit AFR, departmental. They failed to submit departmental simple accounts exam result. That, Lordship, will find it page 73, Lordship. This is the DPC order, Lordship. Minutes of the DPC, Lordship, conducted in the year 2020, Lordship. Page number 73, down below, Lordship. The last paragraph.
Page number?
73, 73.
73.
Correct. Last paragraph, Lordship. However, DPC did not consider the regularization of the following 6 ad hoc assistant engineers on the ground of non-availability of their required offers, departmental simple account, result, etc., which will be considered as and when these records are submitted. So these are the list of the candidates whose case was not considered at that point of time. Now, there were certain subsequent development that took place, Lordship.
Non-availability, yes.
Come to paragraph 3, Lordship.
Paragraph?
176, Lordship.
176.
Continuation of the background story, Lordship.
Yes.
Paragraph 3, I'm referring, last paragraph. This content with the recommendation of the DPC, 3 A's, namely Sri Molitato, Sri Itum Naso, and Rana Tok, serial number so and so, submitted a representation on so and so against the decision of DPC dated 7/9/2020 and prayed for retrospective regularization, Lordship, of their services. And request was turned down after consulting AR department. AR department had suggested to strictly follow the DOPT OM number so and so, dated so and so. Thereafter, the agreed ad hoc AEs, namely so and so, filed a writ petition in Honorable Guwahati High Court, Itanagar Parliament, by case number WPC number 297 of 2021, named as Molitato versus State of AP.
They are not among the private respondents here.
They are not among the private respondents.
Their name was among 20.
On the top, Lordship. On the top, their name will find at the top, Lordship. 1, 2, and 3.
Within the 23 list.
Within the 23 list, 1, 2, and 3. They will be.
So out of 23, 1 expired. 22. Out of
initial list, 23, one expired.
Correct.
So 22. Out of 22, 16
were regularized.
ad hoc were regularized.
Out of 16, 3 of them hesitated through
No,
this
out of
repetition.
16?
Yes, out of 16.
No, out of
Top
16.
3.
Huh?
Top 3.
Okay.
Top
Oh,
3.
they were regular. They were regularized.
They were regularized. But
Okay, with effect from 7/9/2020.
Correct.
Right?
Now what they hesitated on the ground saying that they have to be retrospectively regularized. Now retrospectively, if we see, that is 2006, these 3 engineers, they were appointed as ad hoc AEs in the year 2006. So they claimed that they have to be retrospectively regularized from 2006. That was their claim, Lordship, in the writ petition. Paragraph 4, Lordship. The Honorable High Court in WPC number so and so delivered its judgment by order dated 5/7/2023. The copy of the judgment is placed. Honorable High Court in its judgment directed the department to review their case by convening a fresh. This is wrongly written, not fresh DPC, but review DPC. It's wrongly written as fresh DPC, but it was directed for review DPC, Lordship. For promotion regularization of their services with retrospective dates. There were only 3 petitioners, Lordship, at that point of time. That categorical direction was given by this Honorable Court to review the DPC of these 3 petitioners only, Lordship. The Department of Law had also examined this matter and further advised the department to consider retrospective promotion of the eligible officers from the date of availability of vacancies under promotions quota. Meantime, the Department of PHA received a joint representation from some of the direct recruited regular AEs, PhD after the judgment of Guwahati High Court and Vetting of Law Department. The direct recruited AEs had apprehension that if government reconsiders the position of ad hoc AEs with their retrospective dates, it may disrupt their seniority position, and also that some of the ad hoc AEs were appointed against the post meant for direct recruitment. Further, they also mentioned that as per minutes of the DPC held on so and so, there were backlog of 7 direct recruitment carried forward posts of AEs which were not filled up till 2010. No promotional post to AEs was available. The group of direct recruited AEs also filed a writ appeal, Lordship. Writ appeal to the order of the single bench, Lordship. Bomi, Nyorak versus State of AP and others. Honorable High Court in its hearing dated so and so admitted the writ appeal, called for records and conveyed that the action taken pursuant to the judgment of the single bench would be subject to the final orders to be passed in this appeal. The department later received a joint representation dated 11/7/2024, submitted by both the promotees and the direct recruitees AEs, where they have informed that both the parties have come to a mutual consent to honor the DPC dated 9/10/2020. The 3 ad hoc AEs, respondent number 2, 3, and 4, submits that for early sitting of review DPC and amicable and consensual settlement of ongoing court case, they have agreed to have no objection if retrospective promotion is accorded to them against the vacant promotional post arising after DPC dated so and so. The Honorable...
This 1910 is the review DPC or what?
Lordship, review DPC is...
No, this 1910 2010. It is not mentioned anywhere earlier.
No DPC as such was conducted in the year 2010. I don't know how they have mentioned it. The Honorable Double Bench in its judgment dated 2nd April 2025 directed the department to constitute a DPC to consider the retrospective promotion in terms of the consensus arrived at amongst the parties. The judgment order also states that the impugned judgment and order that passed by the London judge would merge with this order. The matter was under consideration of department in consultation with the law department, whether the order of the court to be complied with or a review petition should be filed or it should be challenged in the Honorable Supreme Court. Meanwhile, all the concerned petitioners, appellants submits affidavits to the department conveying their consent for prospective promotions. So after writ appeal, consensus was arrived that they would not go for retrospective promotions. Rather, they would go for prospective promotions. That was the consensus that was derived in the writ appeal, Lordship. From the date of original DPC, that is 7/9/2020, the Honorable Minister PH NWS and the Honorable Minister Law and Justice took a considered decision to settle the long pending issue in accordance with the affidavits agreeing for prospective promotions. Now here both the parties have agreed for prospective promotions. That is 7/9/2020. Now here, Lordship, when the DPC of 2020 was conducted, Lordship, the private respondents, Lordship, 4 to 9, they were out of the race. Now what they did is, Lordship, they have now in the review DPC, they have included this private respondent 4 to 9, Lordship. So I am agreed, Lordship. We did subsequent DPC that was conducted, Lordship. Lordship will find it at page 156.
No, just a minute. Then
That is the background.
178, come to 178. What is the recruitment rule?
Our recruitment rules talks about 50% by direct recruitment to the post of AE, 50% by promotions. 50% promotion is the.
And what is 11? Moli Tatu. Moli Tatu Jomba Dam Naso.
Now, paragraph 11, here again, there whose name was excluded in the DPC 2020, their name was included here.
So far as 1, 2, 3, paragraph 11, there those 1, 2, 3.
Those 1, 2, 3. They have considered, they have come to a consensus saying that yes, we are no more claiming
7/9/2020.
We are no more claiming prospective promotions. Okay. We will go for prospective.
Who are these 4, 5, 6, 7? All this, okay. This has been redone. Paragraph 11. Paragraph 11. Page 178.
Lordship is talking about paragraph
178, paragraph 11, ARAR. APAR.
Yes, correct.
What is this?
Instead of conducting the review DPC, Lordship, review DPC of 2020.
No, in this 22, there is a list of 22 now. Again,
Lordship.
It includes
the private
1, 2, 3.
Including 1 to 3, Lordship, that was already there.
Then these petitioners, present petitioners, and those private respondents also,
who were excluded in 2020, Lordship.
They were also included.
Here, Lordship.
But you have taken me to that, this thing, page 73, perhaps.
Reason why they were excluded from
non-availability.
Yes, correct. At that point of time,
non-availability and simple account examination.
Yes, Lord.
What is the non-availability? We don't know. 178. But here at 178, if their names are there, then their APAR are also here.
Lordship, that is subsequent development that has taken place, Lordship. Now they are this is of 2025, Lordship.
Just a minute to understand, Mr. This is 178. This paragraph 11. Let us see where are the petitioners. Once again, Tumba Ingo. He is at 12. Then Jomnia Jini, petitioner. Then Motu Kim Hum, petitioner.
19.
Then Jambe Gambu Lama,
20.
20. Senium, right, Doni.
21.
And where are the respondents?
Respondent is
Tasnio. Oh, they have, now they are APAR. Sankyo, okay. Kato. Kato, Tamuk. Chada. Kambuk. Okay. And what is this examination pass?
Lordship, that is mandatory, Lordship. They have to sit for an exam, Lordship.
Is it in the rules?
It is in the rules, Lordship.
And did they pass it?
Here, subsequently, they might have passed it, Lordship. But in the year 2022-20, they did not submit the result, Lordship.
Let us see the DPC, I think 181. Review DPC. You talked about this one, right?
This is the impugned DPC, Lordship.
Let us see.
156.
Let us see. 156 or 181?
181. Review DPC. 156. 13/11/2025.
1311. Page number 156.
Huh? 181 also?
It should be 181.
But yes, that is part of all those records, Lordship. But
anyway, 181 is available.
In 156 is the same documents, Lordship.
156. Let's see.
It's a correct. Same only. Same.
DPC was informed that these now come to 182.
Yes, Lordship.
Serial number 8.
Yes, Lordship.
Read that.
Vigilance clearance and status of accounts examination and annual property written in respect of officers mentioned above was also placed before the committee.
They say that vigilance accounts examination, right?
Correct.
But in the previous, which you have read, I don't know what is this, page 175.
70.
Background note. There is no mention about that examination.
Lordship may kindly come to paragraph 11 of the DPC, Lordship.
Yes. You have taken me to page 73.
Lordship, my case is Lordship.
No, just I have understood your case.
Yes, Lord.
But at the same time, come to page 73. That course was open to the department to consider as and when these records are submitted for the private respondents. They have not closed their case outrightly. It was kept open, right? And these three, serial number 1, 2, 3, they instituted a writ petition, right? And their case was
retrospective
disposed of by a judgment, right? Initially. And that direction was limited to those 3 petitioners, right? So you have to comply with the direction or to file a review or to file a writ appeal. Department did not do anything, right? Then some direct recruitee preferred a writ appeal against this judgment. And I don't know what is that, but it says that then in the course of that proceeding, some consensus or settlement was arrived at, right? The 3 petitioners therein, in the original writ petition, they said that we are not concerned with all. We will be satisfied if we are given promotion from 7/9/2020, right? Then the writ appeal was closed with a merger of the
writ
petition judgment and that agreement. That's 7/9/2020. So they have proceeded. In the meantime, by 73, that was also kept open for the private respondents. See the language, text and tenor, page 73. 2 things were missing. Otherwise, they were senior. Some of them.
Correct, no doubt. No.
2 things were missing. They are APAR and simple account examination results. Right. Those were not available. That is what they said, DPC. And their cases will be considered as and when records are submitted. Now tell me, these private respondents, APARs were discovered or whatever, and whether they had passed the account examination earlier or subsequent to 7/9/2020.
Lordship,
that is a prerequisite, I think. That account examination.
In the year 2020, they did not submit anything as such.
They did not submit.
They did not submit.
That does not mean they that does not automatically mean they had failed.
Lordship, here
That is what
courts direct.
suppose if you can say that they passed it after 7/9/2020, you have a very good case.
Lordship, my
And secondly, if they have no APARs, not available does not mean non-existent. Two things are different. And then when these records are submitted, page 73.
that would be subsequent to our promotions and our name.
If that is so, then you have a very good case, I am saying. If they pass the examination after 7/9/2020, then absolutely you have a good case. Because they cannot be regularized on that day, DPC. Because everything has been given effect from 7/9/2020.
Correct.
Right. If they have failed earlier and passed subsequently this account examination, and if it is a requirement under the rules, then you should get the seniority position.
Correct.
But 73 says those were not placed before the DPC, and they would be considered as and when these records were submitted. Now, this is the small issue. Everything is 7/9/2020, right?
Correct.
You are not agreed by 1, 2, 3 who preferred the repetition.
No, Lordship.
Right. You are agreed by the private respondents. Right?
But
because
Lordship,
by refixing the seniority positions,
Lordship, one
most
thing
of
here,
them are above you now. Is it not?
One more thing, Lordship,
please.
which I would like to submit, Lordship. In that writ petition and subsequent writ appeal, Lordship, in that they talked about review DPC, Lordship, not for the press DPC, not for a de novo DPC, Lordship. Now here, what the department did is, they came up with a fresh DPC, Lordship.
Right. Come to, that is why I have asking you, I've been asking you, come to page 73. This is the DPC.
So while Lordship, as they take the result of this writ petition as well as the writ appeal, Lordship.
No, they have reserved their right. Come to page 73.
So Lordship,
come to page 73 and explain me. You are better instructed than me.
Lordship, that door is always open for them, Lordship, no doubt. That door is always open for them.
They have.
If that was a subsequent
right,
subsequent new DPC, then they have they agree that right.
That is why I am asking you, these APAR or ACRs were not submitted before the DPC.
2020, yes.
On 7/9/2020, and the results of account examination was also not submitted.
Correct.
Right. These are the two factors which denied them promotion at that time. But the DPC observed that their cases will be considered as and when these records are submitted. Right. For 1 to 3, it is review DPC. But for the private respondents, they did not litigate. They thought that our rights are reserved by this order observation. Now tell me, from your side, whether they passed this account examination after 7/9/2020.
Lordship, we presume that they have.
You have a good case for stay. And these ACRs were manufactured later. Not available and non-existence are two different things. Have you understood my point?
Correct, I have understood.
Otherwise, everybody has a right to be considered, right? And they were admittedly on ad hoc basis, most of them were senior to you.
Yes, agreed, Lordship. That is
Right.
agreed.
Now, by this review DPC or phrase DPC, whatever nomenclature, they got their position back, and most of them are above you, except the petition number 1 or 2. Somebody, he is there. Right. But
all or above us.
no, 5 of them,
Except one.
5 of the petitioners are at the bottom,
Yes.
right?
Yes. Only one is
Only one is
above
slightly above.
4.
Only slight,
Four-
he's
four of
slightly
the-
above. Now, that is why I am asking you from page 183. These private respondents, where is the account examination pass condition?
The lordship that I have not annexed.
That
Since,
also is-
since DPC was conducted, I was duly promoted, lordship. It is presumed that I have cleared the exam. Rest of the private respondents, they could not clear.
Take your
It is
call.
presumed that they,
If you
since they
give
could not
instruction, this is
furnish
what-
the
this is
result.
what I found. Fine, take your call, find more instruction if on these 2 aspects.
Lordship, one aspect that I wanted to highlight is, lordship, in the writ petition,
Require consideration, but whether that records will reveal. But if you can make out a case, then I can consider for your interim relief.
lordship, let me,
Otherwise, you have to depend, and their promotion will be subject to the outcome of the writ petition.
lordship, page number 158, lordship, may kindly come. Paragraph 11, lordship, of the DPC minutes, lordship.
158.
158.
Yes, same thing.
And our lordship here in the last line, lordship, may kindly observe, lordship. After last paragraph, after taking consideration the availability of the required numbers of R with the necessary benchmark prescribed, the vigilance clearance certificate, the integrity certificate, eligibility vacancy position, the review DPC recommends promotion of the following officers to the post of assistant engineer PWS from the date of original DPC, that is so and so. Now, in that DPC, they were not eligible, lordship. They were out from the race, lordship. They were not there, lordship.
They were not out. They were not out. Sometimes matriculation result, higher secondary results, some are withheld. Some results are kept withheld. So they were on withholding position because at that time their required documents were not available before the DPC. But DPC made a clear observation that cases will be considered as and when those records were made available. Now that is why I am time and again asking, because I have found this account examination, they have somehow diverted the issue. Otherwise, they were senior to you originally.
No doubt, lordship. We are admitting that,
And
lordship.
if they have the
It is
record,
part of the record.
then why they should not get the seniority? But if they pass the examination, if it is mandatory, subsequently to 7/9/2020, then their regulation should be subsequent to you.
And offer also, lordship.
And APAR available, they are saying.
Lordship, at that point of time, they could not submit. That means it was not available to the DPC, lord.
Maybe the
So, lordship,
APAR.
let them take instruction, lordship. You can list it after 1 week, lordship.
No, this I have to issue notice then, because otherwise the other parties have to come. Because I am considering your case, trying to find out a case. If you make a statement that you have made the statement that
since that
where is the question of account examination pass?
Correct, lordship.
Tell
That
me,
is,
where is
since it is not part of our record, lordship, I cannot firmly
May
make
I
that
just
submission.
point out one thing, my lord. Your lordship may kindly peruse my lord 176, my lord. Because your lordship has been, my lord, noted the first part. That is second part is very important, my lord.
176,
my lord. The 6th person, my lord, their case could not be considered because of, my lord, non-ability of FR, my lord. Right, my lord?
Right.
Down below, my lord. Your lordship may kindly note.
78.
176, my lord. Immediately next below, my lord. That column, my lord. The left of 6, has your lordship noted, my lord? Is later submitted documents, but DPC for their regulation could not be done as the matter was sub judice. Meaning thereby, my lord, they have submitted all the documents, my lord. Right, my lord? But because of my lord, matter was sub judice, their case was not considered. So things are clear now, my lord.
Will issue notice at
My lord.
this time. Only hope is here that if they pass the account examination, if it is mandatory, after 7/9/2020, then you have a case.
We'll try to find it out, Lordship.
But
Otherwise, they have to come up with their own.
Otherwise, ACRs can also be recorded subsequently also. But if ACRs are recorded subsequently, APARs, and without the proper recording officer, reporting officer, or reviewing officer, then you have a case. But
Lordship,
those are
here-
matter of records.
Here, Lordship, misinterpreting, Lordship, Honorable Single Bench judgments, Lordship. They have conducted this press DPC, which they ought not to have conducted, Lordship. That is one ground that I'm contending, Lordship. In
No,
that,
they
in that judgment,
They
it
kept
talks
it
about
reserved.
review only, review of 3 petitioners only, Lordship,
Right,
not rest of the.
right. But they have the option. DPC has the option because private respondents' case are not under litigation. But issue was sub judice. The issue was sub judice because of the institution of the writ petition by 1, 2, and 3.
Subject.
Then direct recruit again, they preferred appeal. Then some kind of settlement. But
that subject
page
was different,
73
Lordship.
observation was there.
Lordship, subject was different, Lordship. That was, it does not talk about the press DPC.
Whatever, review DPC, phrase DPC, deed before DPC, whatever. Ultimately, their rights were there. And that was kept intact. Their ad hoc, from ad hoc status to regularization, that was kept in withholding position, subject to, due to non-availability of record, and it was clearly mentioned that their cases would be considered as and when the records were made available. And in the meantime, litigation came. And sometimes DPC is wary of litigation. Only hope is your passing of examination subsequently.
Lordship, this latest DPC, which talks about retrospective promotions of.
No, Mr. DPC has kept it reserved.
That's it. That was there in
that was there
2020, Lordship.
in 2020. And because some litigation was there, hurt Mr.
Jejini, Lordship.
Jejini. You have tried to make out a good case. And I have given consideration. And Mr. R.H. Nabam, Learned Additional Advocate General, for the response number 1, 2, and 3.
1, 2, 3, madam.
Para. The petitioners, comma, 5, 6 in number, comma, have assailed decision, assailed the minutes of a meeting, comma, held on 13/11/2025, comma, by the Departmental Promotion Committee DPC, comma, purportedly held as a review DPC meeting and a provisional seniority list. Where is that?
Lordship, page 160.
Provisional seniority list.
11/12/2025. Lordship.
Prepared by memorandum dated 9/12/2025. A provisional seniority list of assistant engineer within bracket civil under public health Engineering and Water Supply Department, page 159, huh? Full stop. It is the case of the petitioners that after a decision taken in a DPC meeting held on 7/9/2020, the petitioners were regularized in the post of assistant engineers from ad hoc basis, full stop, in the said DPC meeting held on 7/9/2020. The cases of the respondent number 4 to 9 were also considered as they were found to be within the zone of consideration. Full stop. However, the DPC found that due to non-availability of their required APAR small s stroke departmental simple account examination results, etc. Their cases could not be considered for regularization, and it was observed that their cases would be considered as and when the requisite records were submitted. Full stop. After the DPC meeting held, after the decision taken by the DPC in its meeting held on 7/9/2020, 3 of the 16 assistant engineers so regularized instituted a writ petition WPC number
297
2021, and the said seeking their retrospective regularization. And the said writ petition was disposed of by a judgment and order dated 5/7/2023 with a direction to the state respondents to consider their case for retrospective regularization from the date of their ad hoc promotion, which occurred in the year 2006. Full stop. The said judgment and order dated 5/7/2023 was assailed in a writ petition, writ appeal WA number 28/2023 by a set of directly recruited assistant engineers. Full stop. During the pendency of the appeal, a conciliation no the writ petitioners in WBC number 297/21 agreed for had agreed to forego their claim for retrospective regularization in the post of assistant engineer and had agreed to their regularization on and from 7/9/2020 as like the petitioners hearing. Full stop. The writ appeal is stated to have been disposed of on 2/4/2025. Observing that the judgment and order rendered in WPC number 297/2021 would merge. Full stop. Para. Mr. Genie, learned counsel appearing for the petitioners, has contended that the state respondents ought to have held a review DPC to consider the case, to consider only the cases of the three writ petitioners in WPC number 297/2021. First, but, the DPC considered all the cases of all the 22 ad hoc assistant engineers, as considered in the DPC dated 7/9/2020, and consider their cases by observing by that way, the DPC had expanded its scope in clear violation of the directions made in the judgment passed in WPC number 297/2021. In response, Mr. Navam, learned additional advocate general, has submitted that in the DPC held on 7/9/2020, the cases of all the 22 ad hoc assistant engineers within the zone of consideration came for consideration. It was only due to non-availability of the APARS stroke departmental simple account examination results, the cases of the private respondents could not be considered at that point of time. But the DPC reserved the right to consider their cases as and when those records were made available. It is therefore, he has further submitted that immediately after 7/9/2020, the issue of regularization of ad hoc assistant engineers was under litigation. It was
176.
only on 2/4/2025. The writ appeal after disposal of the writ appeal, the cases of the private respondents were possible to be considered. As therefore, along with the three petitioners in WPC number 297/2021, the cases of the private respondents were also considered. in the DPC meeting held on 13/11/2025. Full stop. As the records pertaining to APARS and simple account examination results were available, the cases of the private respondents were also considered. Full stop. After finding them eligible to be regularized, comma, all the 22 ad hoc engineers were regularized, were decided to be regularized by the DPC. And as the private respondents were senior during ad hoc service to most of the petitioners, by the way of regulation, comma, their seniority positions were restored. This is your case. The matter would require further consideration. The issue notice returnable on so and so. As Mr. Nawam has appeared, accepted notice on behalf of 1, 2, and 3. No formal notice, extra copies, 2 working days, steps upon respondent number 429 by speed post within 3 working days from today. The prayer, learned counsel for the petitioner has made some submission on the interim prayer. The interim prayer is kept open for consideration.
Yes, Lordship, since they might go for
subject to at an appropriate stage.
My lord, this notice is returnable, my lord. Notice.
Date after 4 weeks.
4 weeks.
4 weeks.
Give it date.
25.
Yes, that interim part may be kept open, Lordship.
In any way of the matter, it is the impugned decision of the DPC regarding the private respondents are impugned decisions taken in the meeting of the DPC held on 13/11/2025 and the provisional seniority list published by memorandum dated so and so, it would be subject to the outcome of the petition.
May I please, Your Lordship?
Yes.
Lordship, I'd like to remind something regarding the item number 15. Since for the morning when the single bench started, the respondent side took the adjournment. I mentioned this matter. So this is a misunderstanding regarding not I'm not present on the point of time. So later on we are discussed regarding these things and fix the matter on, if possible, my lord, on 24 of this month. Fix matter. That much I pray. And on behalf of the petitioner side.
It was fixed on 6 May. 2 weeks.
6 May.
The respondent, they asked for 2 weeks on 6 May.
Okay. Okay.
24 May. April. April 24.
Okay. Right, good.
Yes,
Much obliged. Yeah.
My lordship, I beg to mention item number 16.
Yes.
Now there is a proceeding which is fixed in permanent bench via VC, due to which the conducting counsel R. Sunar could not appear before this court, and I have taken the consent from all the parties, my lordship.
You are for a petitioner?
Yes, my lordship.
You are Miss?
M. Jarang.
On behalf of?
R. Sunar.
Okay, has made a prayer for adjournment. It is submitted. Consent has been taken from the learned counsel for the respondents to make the prayer.
My lordship, the matter can be fixed on 27th of.
As sought for.
Yes.
And agreed to by the learned counsel for the parties. This is the case on 27.
Much obliged.
27/4. 27/4.
Yes.
Mr.
M. Boko.
private respondent 3.
Okay, learned counsel for the private respondent is present.
Much obliged.
Item number 5.
May I, Your Lordship? Lordship, this matter to be listed in the next week, Your Lordship.
This matter is to be listed
Next week, Your Lordship.
next week.
Yes. In this matter, AAGRS Nabam is appearing due to some medical problem. He just left the court, Your Lordship.
Okay.
This matter, since 2000 matter, it was regarding supply of the school kit items. That was already, tender was awarded, every bill has, everything is exhausted. Man. But why it's kept pending, it's become infectious. Man.
Infractuous.
No.
But petitioner has to say.
No, my lord. No, my lord.
Petitioner is not saying infractuous.
Yes, my lord. My lord, there is, my lord, issue is still live, my lord.
Okay. When do you want?
Next week, Your Lordship, on Monday.
Or Friday?
Monday, Your Lordship.
Monday, too many matters. Friday?
Friday, okay, Your Lordship.
Friday?
My lord.
Okay. Mr. Lampu.
Yes, my lord. H. Lampu.
H. Lampu for the petitioner and Mr.
I'm for responding to 5.
Learned counsel respondent 5 are present. On the prayer of Miss
P. Pangu, Your Lordship.
Sangita.
P. Pangu.
Or P. Pangu. Learned counsel on behalf of Learned State Council on behalf of Mr. R.H. Nawam, Learned Addition Advocate General, Honorable Police. This is the case on Friday.
All right.
Yes, Your Lordship.
Item number 6.
May I plead, Your Lordship?
Yes.
This is a contempt petition, my lord. We have filed IA for the implement of respondent number 8 and 9. Your Lordship was pleased to allow this IA application, but we were supposed to file amended course title, but we have not filed it. So I may be given 2 days time, and the matter can be listed on Friday.
Okay. And Mr.
Esmo.
Learned counsel for the petitioner submitted that he will file. He has prayed for, has sought for listing of the case on Friday in order to file the amended cause title in the meantime. Miss so-and-so,
Ms. Ojarang, Your Lordship.
learned counsel for the respondent number
Respondent number 4, appearing on behalf of Emmet.
is in attendance.
Okay.
This is the case
Much-
for Leon so-and-so.
All right.
Item number 9.
Bengia Mama. Bengia Mama. It has come for what purpose?
Lordship, may I produce, Lordship, the acknowledgement of receipt of the notice by the respondent number 28, Lordship. Private respondent number 28.
Real last has prayed for.
Notice was issued to respondent number 8, private respondent number 8. Through respondent.
Private respondent number 28.
28, Lordship.
28.
Through respondent number 4. ma'am.
28. True respondent number 4.
Oh,
Yes.
Lordship.
Okay.
Yes.
They are serving employees.
Yes, ma'am.
Yes, Lord.
Okay. Twenty-four two. 24-2.
This is a case of, my lord, illegal appointment of lady.
Just a minute. How many petitioners?
Or 2 petitioners. sir.
Who is for the other respondents?
My lord, I am for the private.
Except 28 for others.
Yes, ma'am.
You are Pisha?
Yes, ma'am.
heard Mr. B. Picha, learned counsel for the petitioner, and Mr. Kamduk.
Yes, madam.
D. Kamduk, learned counsel for the private respondent, respondent number 6 to 27 and 29 to 42.
Yes.
First up, Miss
P. Sangeeta, Your Worship.
B. Shangita.
P. Sangeeta.
P. Shangita, learned junior government,
Yes, Your Worship.
has submitted that in deference to the direction made in the order dated, in deference to the order dated 24 to 2025,
Yes.
comma, service of notice has been duly effected upon the respondent number 28. Full stop. Miss Sangeeta has placed a copy of the notice so served upon the respondent number 28, wherein the signature of the respondent number 28 is reflected. First stop. In view of the office letter dated 21/11/2025, comma, placed by Ms. Sangeeta, comma, is kept with the case record. Full stop. By service of notice upon the respondent number 28, comma, all the service of notice is complete.
Yes, madam.
Full stop. Affidavit filed?
Yes, madam. Exchange, yes, madam.
Yes, what do you want?
28, madam,
Okay. So,
for admission hearing.
Land counsel for the parties released the case on 28 in the admission column.
Madam.
Obliged.
Obliged.
Item number 11.
Kasi Punso. WPC is issued by the venture. Issue notice. There is no representation. There is neither representation on behalf of the petitioner. Petitioners today on call, nor any affidavit as regards service of notice upon the respondent number 4, 5, and 6 by way of Dusty has been filed till date. First of Miss
K. Wangmu.
K.
Wangmu.
Pangmulan, junior government for the state respondents is present. First of, in view of the above, commanded the case be listed after 2 weeks on a date to be fixed by the office. You have filed the affidavit.
No, my lordship.
You in the meantime done 3 weeks. You in the meantime file the state
Extra
respondent.
copies are not served to us.
Oh, after 2 weeks.
Item number 13.
Lordship, I'm appearing for all the respondents.
Yes, yes,
One and
Mr.
two.
Picha. Your Picha is for what?
Respondent number 3, private.
3.
Yes.
Affidavit in reply not yet filed. There is no representation on behalf of the petitioner today on call. Whereas Miss T. Wangmul and a junior
P.
government.
Sangeeta, Lordship.
Huh?
Sorry, P. Sangeeta, Lordship.
P. Sangeeta, Lane junior government advocate. For the respondent number 1 and 2.
Yes, Lordship.
And Mr. B. Picha, learned counsel for the respondent number 3.
Yes.
Are in attendance. After 2 weeks then.
Yes, Lordship.
We dismiss this for non-prosecution.
Non-prosecution?
Yes, ma'am.
What
Because
is
this petition itself is not maintainable.
not maintainable?
Yes, ma'am. They have to approach records authority, ma'am. Person.
Whether, okay,
Issue is relating to compensation. Dispute over the land.
generally I follow 3 times. Okay, we'll put it on Friday. Then again on the next week. Then we'll dismiss. In view of non-representation on behalf of the petition today on call, the learned counsel for the respondents have submitted that the writ petition is not maintainable in view of
Apportionment of land has to be decided by the reference authority.
okay, in view of availability of remedy
Yes, ma'am.
before the reference authority.
Yes, ma'am.
Post up as there is no representation on behalf of the petition to the uncall, let the case for initial justice be listed again on Friday.
Ma'am.
All right.
Item number 14.
May it pleases your lordship.
Yes.
Your lordship, in this writ petition, the petitioner is challenging the proceeding pending before the Honorable for the State Human Rights Commission, that is before the respondent number 2, and notice has been issued on the 16/12/2025, your lordship. Here the affidavit from the respondent number 2 is yet to be filed, your lordship. The affidavit is very important, your lordship, in this case for adjudication.
Who has filed affidavit till date?
Respondent number 5, your lordship.
Yes.
Respondent number 5.
Yes, your lordship.
And according to you, who should file the affidavit?
Respondent number 2 and 3, your lordship. The Honorable for the State Human Rights Commission.
Whether can you expect the State Human Rights Commission to file the affidavit? You represent respondent number 2.
Yes, Lordship. We will file our wakalat number power today, Lordship.
Acting chairperson, State Human Rights Commission. Is it required to file because you challenge the legality on what ground?
Your lordship, the proceeding and the order passed by the Honorable Pradesh State Human Rights Commission, the order passed by the respondent number
on jurisdiction ground or what? On jurisdiction ground?
On jurisdiction ground.
No, not required to file. Respondent number 2 is not expected to file. Respondent number 1, you can say. Respondent number 1, you can say.
Your lordship, respondent number 2.
This acting chairperson, is he a judicial officer? Former judicial officer?
No, your lordship.
Your Lordship, on behalf of respondent number 5, we have filed ADC. Meow. And on behalf of respondent number 6, Your Lordship, ADC Godunsa, we are filing.
You are filing it?
Yes, we will be filing.
And whether you will file the affidavit for respondent number 1, take a call? Huh?
Not recording, because they are challenging the order passed by the ADC Meow and the ADC Godunsa. They are agreed by the.
Let me read the order first.
Yes, your lordship. Lordship, may kindly peruse order passed on 16/12/2025.
I am reading it. I am reading it.
Yes, lordship.
So basically, Jurisdictional issue.
Yes, Your Lordship.
Okay, let the respondent number 6 file his affidavit. We don't think it requires any affidavit from the respondent number 2 or 3. One is not required to defend his own order on the grounds of jurisdiction. It has to go by the provisions of the Protection of Human Rights Act 1993.
Yes, Your Lordship.
Anyway, you are enjoying an interim order.
Yes, Your Lordship. That interim order may be continued.
Heard, Mr.
S.K. Chakma, Your Lordship.
S.K. Chakma, learned counsel for the petition through the virtual mode. Who is for respondent number 1, 2, 3, 4, 5, 6?
Sir, I'm for Lordship, I'm for 2 and 3.
2 and 3.
Yes, we will
Miss
power. Y Gao, Lordship.
Y?
Gao.
Gao. Learned counsel for the respondent number 2 and 3.
Yes, Lord.
Miss?
Your Lordship, I'm for 1, 4, 5, 6, 7, 8, 9, and
Sangita, right?
P. Sanjay.
Miss P. Sangita, learned junior government advocate for the respondent number 1, 4, 5, 6, and 7,
7,
and 8,
9,
9,
and 10.
and 10. And Mr. K. Lawyer, learned central government counsel for the respondent number 12. What about 11? Notice served.
Your Lordship, we have taken a step, Your Lordship. It is yet to be returned. I think we have not checked.
It is for only service report. The case has been listed. Anyway, Ms. Sangita has submitted that the affidavit in opposition, the counter affidavit on behalf of the respondent number 6 has been sent for vetting.
Yes, Lord.
And has sought for listing of the case after 3 weeks in order to file the counter affidavit in the meantime. Yes.
Your Lordship, since I'm an outstation counsel and we have matter fixed on 7, Your Lordship. Can it be this matter be fixed on 7 May, Your Lordship?
We don't know. So it is service report. It has to for service report of respondent number 11. The case has been listed for that purpose only. But respondent number 6 should file the affidavit. Anyway, you are in virtual mode.
Your Lordship,
in view of the office note, in view of the office note dated 20/04/2026, await for the service report in respect of the respondent number 11. Post of place the case on so and so of the 3 weeks.
And Lordship,
13.5.
13.5. The interim order passed earlier.
Lordship, 13.
Interim may be continued.
Yes, tell me.
22, Your Lordship.
22.
22 May.
22/05/2025, 6:26. The interim order passed earlier shall continue till the next date of listing.
and Lordship, extra copy may be served upon respondent.
Oh, Mr. Chakma, you have not served extra copies. They are
Yes,
saying.
Lordship.
We will serve it, Your Lordship. Earlier we have served.
Mr. Chakma is to supply. How many copies you need?
Lordship, 1.
One. A copy of the requisition along with annexer to Miss So-and-so within 2 working days from today. You have local counsel here?
No, Your Lordship.
Within how many days you can furnish a copy of the requisition?
We can serve e-copy, Your Lordship. We can serve e-copy.
Within how many days?
Within a week, Your Lordship.
Okay, within a week.
Obliged, Lordship.